Hi, everyone. I'm Liz Kruger. Welcome for being with us today. This is part 4 of our 4-part series at lunch hour relating to housing issues. I want to remind everyone the topic of today is co-op and condo owners' rights and resources. And you might be watching on Zoom or Facebook or calling in. I want to remind everyone that there is in the Zoom and the Facebook systems a closed captioning option available for this afternoon's event. If you're on Zoom, click live transcript in the meeting controls to start viewing closed captioning. If you're in the Facebook Live event, you'll see a setting button on the bottom right-hand corner of the video. Click CC for closed captioning to activate the process. This is a really great resource when being ever on a Zoom or other webinars, because even if you even just have slight hearing issues, reading along as you're listening can be really clarifying of what you're hearing and absorbing. So this forum, like all of our events, is being recorded, and everyone who RSVP'd will receive an email with links to the video, the resources that are posted in the chat, and the presenter's PowerPoint in the next couple of days. So even though you'll be getting an enormous amount of information, don't panic. You don't have to write it all down because it's going to be sent to you within a couple of days. I also want to remind everyone that they have an opportunity as issues come up to write a question into the Q&A section of either system. We have many, many questions already. We've got an enormous number of questions, but if there's any extra time to add them, we will try to do so, although I suspect that's not going to be possible today. I am very excited to be having this event because, frankly, my office often receives calls from shareholders and condo owners who face a host of issues, from struggling to pay maintenance, dealing with their board or management company, understanding who's responsible for repairs and building upgrades, the rights and responsibilities they have as co-op shareholders and co-op owners are derived from a complex series of laws, regulations, individual building bylaws, and other corporate documents. These multiple laws, regs, and governing documents are frequently difficult to navigate and comprehend without legal guidance. So I'm very pleased we are joined today by a legal expert who can provide an overview of co-op and condo law and the resources available to shareholders and owners. We're very fortunate to have Rosemarie Cantanno, Associate Director of the Consumer Protection Unit as the New York Legal Assistance Group. Rosemarie will review the difference between co-ops and condos, how to handle issues with the board of directors in your building, and financial resources for those struggling to pay their maintenance or mortgage. After her presentation, we will have a live Q&A where Rosemarie will get to many of the pertinent questions submitted to our office in advance or during the webinar today. I am really pleased to introduce Rosemarie Cantanno. She has worked with my office and constituents for quite a few years, and she always is an invaluable resource. So I'm going to hand it to her, and I will disappear. She'll make her presentation, and then I'll come back for Q&A. Good morning, good afternoon, Rosemarie. Thank you so much for being here.
Good afternoon. Thank you, Senator. And thank you all for signing on today. If you give me 2 seconds, I'm going to share my PowerPoint presentation. So just as the Senator told, my name is Rosemarie Cantanno, and I'm the Associate Director of the Consumer Protection Unit at NYLAG.
Excuse me, Rosemarie, we can't see your PowerPoint.
Oh, my apologies. Hold on. This again. Okay, hopefully you can see it now.
Yep, all set.
Okay, sorry about that. You would think after all these years I'd have this down, but not quite. Anyway, just real quick about NYLAG, the New York Legal Assistance Group. We're a leading nonprofit that provides free legal services, financial counseling, and engages in policy advocacy efforts to help people experiencing poverty and for all sorts of issues. So today the senator asked me to talk to everyone about co-ops and condos, and how is a cooperative apartment, I'm going to call it a co-op going forward, different from a house or a condominium, a condo. And there are some very distinct differences. The main difference between a co-op and a house or a condo is that a co-op is considered personal property, whereas a house or a condo is considered real property. So when you buy a house, right, people always say, well, you go to a real estate broker. So that house is considered real estate. And there's very specific laws that show how a house has to be treated, mortgages, things of that nature. However, a co-op, when you buy a co-op apartment, you're buying shares in the co-op corporation. So it's a transfer of personal property, which is governed under what a form of law called the Uniform Commercial Code. So it's treated differently. It's treated the same way in kind of as your car or your furniture. Okay. Now, unlike a house or a condominium, there's no deed, right? When you buy a condo or you buy a house, you sign a deed and a whole bunch of other types of forms, and they get filed with the county clerk, and everybody can go and see that you own 123 Apple Street. That's not what happens with a co-op. With a co-op, you are given a stock certificate, and that stock certificate tells you how many shares of the corporation you have. Now, it'll reference the apartment that you're in, how many square feet and all of that nature in other documents with the co-op, but that stock certificate doesn't get filed with the county clerk. So it's not easy for someone to go and see actually who owns a co-op. As a co-op owner, I know you all know that everything is controlled by the board and the bylaws, and we're going to talk a lot about that as time goes on. But again, because it is personal property, you do need to think about what happens when you pass away, or what happens if you want to add someone to your stock certificate, your child, a new spouse, etc. If your intentions are that when you pass away, that other person on the stock certificate is going to get the apartment free and clear. Well, not free and clear, meaning if there's loans on it, the loans are still there, but that it's going to go to them and no one else, then what you should do is you should ask to have your stock certificate amended to have that person done as becoming a joint right of survivorship. Excuse me. What joint right of survivorship does is it basically says that if one person on the stock certificate passes away, the co-op goes directly to the other person. You do have to get permission from your co-op board to do this. And there are some co-ops who won't do it, but it is something that you may want to think about. Otherwise, when you do your will, and if you own a co-op, it's really a very good idea to have a will. This way you can say where that you want it to go. One thing that I always tell people about their co-ops is when you're thinking about who you're going to leave your co-op to, you can leave your shares, the ownership, to anyone that you want. It doesn't mean that the co-op board has to allow that person to move in. That person is still going to have to go through the same process as if they were buying the co-op with the board. And if a board finds that they don't think they're the right fit, or they don't think they have the finances, the board can refuse to let them move in. They still have the right to sell the co-op to someone, but the board can prevent them from moving in. Okay. When you get your co-op, you also always sign a proprietary lease. This is a lease that basically outlines all the rules that you have, just the same as if you were renting an apartment. And proprietary leases are all different and have different things in them. And usually the co-op board will make it 99 years. This way, you don't have to keep coming back every year or two and sign a new lease with them. And when you sell the co-op, often that lease is assigned to the next person. But it basically outlines the rights and responsibilities of those on the stock certificate. It usually has all of the major things that you can and cannot do. Okay. In addition, most co-ops have bylaws and house rules. you're going to hear me a lot during this presentation, and even when I'm answering questions, most likely say we have to check the bylaws. The bylaws are basically the rules, and they can be from major things like the process for voting in board members or who can run for the board to fines. So for example, if you put your garbage in the wrong place, there could be a $50 fine. I live in a co-op. So for example, if I have to move a piece of furniture, I have to give a check to be held for a couple $100 down with the doorman, and I have to use a specific elevator and all of that. And then you'll see number of pets, right? A lot of times people will say you can only have 2 cats, or you can have 1 dog, or you can't have a dog more than 50 pounds. Some co-ops will tell you that you can't have certain types of pets, like pit bulls or Doberman pinschers, for example. And that's usually for people to know, is because a lot of times there's problems with homeowners insurance when you have those types of dogs in the building. But it also can be something as simple as you can only put white Christmas lights on your door, or you're not allowed to store your bike anywhere but one specific place. Okay. Now we're going to talk about maintenance. Nah, everybody's favorite subject, I'm sure. When you buy a co-op, maintenance is always paid monthly to the cooperative, just the way a rent payment would be made. This is in addition to any mortgage or any other loans that you have on the co-op. So people always say, I don't understand. I pay $1,200 a month. Where does it go? So things that it's supposed to cover are the essential services in the building: elevators, the building maintenance, landscaping, gyms, pools, any kind of common area that everyone in the building enjoys. It goes to pay the salaries of building staff, doormen, porters, the superintendent, gardeners, whoever else you have on payroll. The real estate taxes for the building. You pay a specific amount of real estate taxes for your apartment. But there is also real estate taxes on the building as a whole, and maintenance is used for part of that. Now, I'm using the term maintenance here. For a lot of the condo owners, you may refer to it as homeowner association fees. And usually it's a lot less, and it covers less stuff because you don't have maybe some of these, landscaping and gyms and pools, if it's not a big building. So, okay, and you pay your own real estate taxes. In a condo, you pay your own real estate taxes the way you would for a house. And then there may be there should only be a small amount of real estate taxes left over for the rest of the building. Fire insurance for the building. Obviously, if God forbid the building burns down, you want to be able to rebuild. Oops. Okay. It also goes towards any mortgage or other debts on the building. Many, many buildings have what we call underlying mortgages, which is money they took out maybe because they needed $2 million to fix the roof, or maybe they needed $1 million because the garage was falling down. So if the mortgage is taken out by the building, then they pay those payments out of your maintenance. And in some buildings, maintenance can cover different types of utilities. It can cover electric or heat or air conditioning, cable, delivery service, whatever your particular building has. The other thing it does is it funds what's called the building's reserves. And I want to talk for a minute about what that means. As a co-op building, you want to have money in your savings account, so to speak, money to go to on a rainy day. You're also, if your building ever needs to borrow money, the lender that they go to is going to want to see that there's enough money in the coffer, so to speak, so that if something does happen, it can be fixed. Or if something comes out of the blue, electricity has gone through the roof, I know, for example, and my co-op building just at our meeting recently said that it has doubled the amount of money that they need for electricity. The hope is that the building's reserves has enough money so that they won't have to come back and ask the shareholders to pay any type of assessment, which we'll also talk about in a minute. Okay. One thing I always tell people, because sometimes I think it's not told to you correctly by your buildings, their insurance policy is not going to cover what's inside your unit if something happens. So let's say that there is a fire in your apartment. The co-op is going to be responsible for, the walls and all of that. But if your furniture gets destroyed or your jewelry or anything of that nature, your appliances, it's not going to cover that. So you want to make sure you get a co-op or a renter's policy. They actually are extremely reasonable, much more reasonable than house insurance, but it really can cover you in case something happens. There are a lot of buildings, for example, the building I live in, where their major insurance company, there's a $10,000 deductible. So they'll cover the first $10,000 of certain things, but they won't cover anything over $10,000. So I have a co-op policy that, for example, when my floors got destroyed, that came in and paid for the difference. Okay. I know I use the word assessments, and unfortunately, I'm sure a lot of you on here probably have been hit with assessments. Co-op boards levy assessments when unexpected expenses occur. Something happens with the building's windows, something happens with the building's garage, and all of a sudden they realize they don't have money in the reserves to take out to fix it. So what they'll do is they will often decide, and this is decided by the board, they will decide that they are going to add more money to each of your monthly maintenance payments. It can sometimes be as little as $20, and sometimes if it's a major expense, it can be something that's really hard for people to do. You obviously have the right to know what the assessment is for, and you have the right to know, how they got to their numbers, but almost every set of bylaws does say that assessments can be put on. They should be equally charged to you by the number of shares. Normally, the more shares you have, the higher your maintenance. Therefore, the more shares you have, the higher the assessment. And assessments can be for a short period of time or a longer period of time. Normally, assessments are not forever. The whole idea of the assessment is to make up for the money that the co-op had to put out. Okay. Failure to pay your maintenance. If you do not pay your maintenance, you can lose your shares and you can be evicted. Just like a house or a condo, you can be foreclosed on. So it's really important if you fall behind or you're starting to have an issue, talk to the management company, if there is one, or the board about a payment plan. If you fall behind, 2 or 3 months for, let's say you're sick and you can't work for 60 days and you're having trouble for those 2 months. Once you get back to work, call them up, say, look, is there any way that I could pay, $25 extra a month for the next year or two to make up for it? Don't open the mail. Don't ignore it. I know it's hard, especially since you're living in the building with these people. But it's really important that you stay in contact if you're having any issues. Also, you should try to speak to an attorney or a housing counselor. There could be programs that help you. One of the things that NYLAG helps co-op and condo owners with is if you fall behind on your maintenance, we can try to see if we can get you what's called a one-shot deal for the city. I know people know about it for renters, but HPD actually does right now help co-op and condo owners with back maintenance and back mortgage arrears. So if you are having a problem, please reach out to NYLAG or another legal service provider so that we can see if there's a way that we can bring you current. Okay. The board of directors. And I know that unfortunately there are a lot of board of directors out there which don't do the best thing for the building. And we're going to talk a little bit, and I'm sure people are going to have questions about their boards of directors. But the day-to-day activities of the co-op are controlled by the board of directors, and they are normally voted in pursuant to the bylaws. So your buildings should be having elections to put people on the board. Now, often they will hire a management company who will come in and they'll do the day-to-day things like send out the invoices for the maintenance or, do the work orders when you need somebody to come up and do something in your apartment. But the actual major decisions, including who is hired as the management company, is made by the board of directors. What happens if you don't agree with the board or if you really think the board is doing something wrong? You can try to lodge a complaint with the management company, see if they can come in as an intermediary. There are, for example, the building I live in, if there is an issue, you can ask for what's called a mediation, and they will find other shareholders who are neutral. And sometimes, they'll sit everybody down in a room to see if something can be figured out. You can do a petition. Maybe the board doesn't realize that this is as big a problem, or the board is really busy, and putting something in front of them with 50 signatures on it might make them pay attention. You can also run for the board yourself. Usually they're open. Normally any shareholder can run for the board. So, it's a way to get in there and make changes and see what's going on. And if things are really bad, when I first moved into the co-op that I live in now, they're actually hired a lawyer and filed a lawsuit to have the board members removed because there was embezzling going on. So there is a way legally. It is a long and difficult process. There are attorneys who do this for a living. But there is a way to have the board removed if they're not doing what they're supposed to. So what is the responsibility of the co-op board and for the co-op itself? A lot of times people ask me, they say, well, they came in to fix my floor, and in the process, they broke my dishwasher. Well, they can't do that. They have the same level of having to use reasonable care as any other person you would hire. So if you had a stove delivered from the local store and they drop that stove and they cracked your floor, that store should be responsible. If the building takes it upon themselves to fix something, then they have to use that same reasonable care. And if it's a large thing, they should put it under their insurance company for you. A lot of times, if it's small, the building will pay for it itself because it's easier than going to the insurance company. But they definitely can't say, well, we're the co-op and we're not responsible. Now, may you have to sue them in small claims court or whatnot? It's possible, but they don't have the right to destroy your things. Okay. Normally, they are responsible for everything outside the apartment walls, they'll say. So, for example, if the outside of your building is leaking into your living room because they haven't kept up the facade, right? That is something that they are responsible for. But if your dishwasher breaks, or, there's always arguments with co-op buildings and condo buildings with whose pipe is it? Was it the pipe that's the main pipe, or was it the pipe that's under your sink that's only yours? So sometimes you have to, you get into these difficulties. Sometimes people go to their own insurance company first, get it covered, and then we'll go after the board. But you should check your bylaws for your specifics. Okay. I want to talk briefly about subletting, and because this is becoming more and more of an issue with Airbnb and Vrbo and all of those places. The co-op has the right to say whether or not you could sublet. It should be uniform for all owners. They can't let one person sublet and not the other, unless there is something in your bylaws that says 20% of people can sublet, and once we get to the 20%, then we're not going to allow any more sublets. A lot of buildings also do that with rental units. Like they won't let one person have 20 apartments and rent them all out. And right now, most co-ops do not allow Airbnb and Vrbo, and I think there's even laws coming into effect to try to keep strangers out of your building so that you don't have to worry about who you're going to see in the laundry room. Okay. A lot of people, in order to buy their co-ops or for whatever reason, need to take loans out on the co-op. We call it a mortgage because we think of it the same way we do with a house, but technically, since it's not real estate, you technically don't take out a mortgage, you're picking out a co-op loan. If you have a loan on your co-op and you're like, oh heavens, I can't find my stock certificate, what happened to it? When you have a loan, the loan company holds on to your original stock certificate and your proprietary lease until it's paid off. When you pay it off, they'll send it back to you, or if you sell it, they'll bring it to the closing, but they hold on to it to make sure that you're not also selling it to someone else, because as we mentioned before, you can't just go to the county clerk and look it up as easily. They file something called a UCC, but it definitely doesn't have all the information that a mortgage document on a condo would have. Okay. If you have a loan on your condo and you fall behind, you might hear people say all the time, well, foreclosure takes a year or two. It takes a really long time. That is not true with the co-op. Because a co-op isn't real property, it is a much faster foreclosure and you can lose it in a few months. So it's really, really important that if you are falling behind on your mortgage, that you try to work out something with the lender, and that you reach out to a lawyer, to legal services, especially if you get any kind of official notices. They auction off shares just the way they do with houses. Okay. Real quick, if you want to sell your co-op, you should hire a reputable broker and list it at fair market value. There have been instances where co-ops, other people who live in the co-op, been like, oh, my daughter wants the house. Let me give you, she'll give you $60,000 for it. And maybe it's worth $250,000. So it's really important that you find out before you make any agreements with anyone, really what your co-op or condo is worth. Co-op boards will not let you sell at a bargain price because they want to keep the building up, right? If you sell for $200,000, then the next person who buys in the building is going to want to pay $200,000. So what your neighbor sells their apartment for directly does affect what your apartment is worth. I always say when it comes to houses, co-ops, condos, it is worth what somebody is willing to pay for it. However, a lot of co-ops will allow you to let someone pay less if, for example, it's your daughter, or if the person who was on the stock certificate passed away and their grandmother wants to buy it. Sometimes they will allow that because they'll be able to notate why that is happening. Some co-ops do have lists of interested buyers waiting. If you do know what your co-op is worth and there is somebody who's willing to pay market value, this could be a way to avoid having to pay a real estate broker. Okay. Anyone you sell to is going to have to submit an application. They're going to have to interview with the board and management company. Even when you just add someone, I'm working with a client now, she just wants to add her daughter to the stock certificate. They are making us do an entire application. They want to talk to her. They want to see her financials. So keep in mind that, the person that you offer to sell it to, you want to make sure actually is going to be able to pass, can afford it, example. Other thing here, some co-ops dictate what percentage of the purchase price can be borrowed. A lot of co-ops will say that you can only borrow 75% of what the co-op is worth. They don't want people being at the point where if they needed to sell, they wouldn't be able to pay off their loans. Okay. And then there's some resources that I have listed here on, and as the senator said, they're going to send you all of this, so you don't need to go writing all this down, but there's 2 pages of different types of resources. There are city programs that can help. Sometimes there are state programs that can help. So really, if you are having issues, please reach out. This is our NYLAG is us. I have a staff of attorneys and paralegals who would be more than willing to help you. The phone number on here, you can call. There isn't a live person there. You leave a message, and with a few days, someone will get back to you. And with that, I will turn it back over to the senator.
Well, thank you so much, Rosemary. There's so much material to sort through, and really appreciate everything you just shared. And now we're going to jump into where I'm asking you some questions and hopefully you can answer. We are not going to try to sort of put you on the spot as if you're the lawyer representing anyone, because that's not the deal. But we have tried to focus on some broad questions that we think are not so uncommon out there. So starting out with co-op board issues, because there always seem to be a lot of them. Are there requirements for co-op board of directors transparency, like distributing board of directors meetings minutes? What kind of co-op documents are unit owners legally entitled to obtain from management? Again, reference board minutes, bank statements, I guess audits, etc. What's the rule?
So as a shareholder, you have the right to know the financial health of your building.
Oh, Rosemary, I'm supposed to ask you to stop sharing the screen now so that we just see you.
I can do that, I think. Yes, I can figure out how to do that. Just bear with me 1 second.
Sure.
There we go.
There we go.
So yes, so as a shareholder, you have the right to know the financial health of the building. So you certainly have the right to see the financials of the building, to know what's in the reserves. Board meetings, usually in the bylaws, it'll say how the board meeting what minutes are to be distributed. So your specific bylaws should give you that information, but your board cannot stonewall you and just say, don't worry about it, it's fine. Anyone who's buying in the co-op is going to get access to those before they buy it. So they should definitely be available for those who already own the apartments. And
Great.
sometimes if you're having trouble with the board, if you can find out who the attorney for every board, they have attorneys for the building, and sometimes you can get them that way. Sometimes it's easier to get it through the attorneys.
Because technically, while the attorney is hired by the board, if you're a shareholder, aren't you entitled to the same information they give the board?
For the most part. I mean, if you called and you said you wanted to see like every invoice for the gardener, right, they would probably tell you no. But for major things with the building, and especially the financial health of the building, how much is in the reserves, how much is the mortgage on the building, you have a right to know that.
Okay, thank you. Is it legal for my co-op to charge me legal fees from a court case where the city took them to court?
So I'm not sure what the city took them to court for, but
Right?
for the most part, that would be considered, defense of the building, so to speak. So usually in all of your proprietary leases and bylaws, it will say that the shareholders pay the legal fees for the building. Now, if it's malfeasance to the point where, somebody's embezzling or something of that nature, that's a little different. But if, let's say, there was an issue with the building and the Department of Buildings came in and slapped a violation, they normally would pass that over to if they didn't have enough money in the reserves to pay it, they would pass it through to the shareholders.
And sort of variation on, well, it's not really the same question. Can management and the co-op board charge me legal fees if I owe back rent and they've taken me to court? Do I owe I owe those fees to them?
Yeah, just like mortgages, almost every proprietary lease says that if you fall behind, you'll pay reasonable attorney's fees. Now, if you're $3,000 behind and there's $12,000 worth of legal fees, you might have an argument that it's out of proportion, but they do have the right to pass those fees on.
What if I feel that I'm being discriminated against in my building, perhaps because I am a senior citizen, or perhaps because I have a relatively small number of shares? How do I address that if that's happening?
So you have the same rights as if you were a renter or a homeowner. You can go to the same city agencies and lodge complaints. I know it's hard, right? Because you live there and you want some peace and tranquility in your home, right? You don't want to worry about who you're going to run into in the hallway or the elevator, but you have all the rights that everyone else does. And I know that the senator's office helps people all the time with connecting them with those agencies. So I highly would recommend you reach out to her office because her people are wonderful at connecting people with those kinds of organizations, better than I am.
So we get these questions all the time over the years. What if you and other neighbors believe that you have a corrupt board and or a corrupt property manager, but election results haven't changed the story because you're not even sure you can trust the election results because the people who you think are corrupt are the ones controlling the count of the vote? What do you do in that situation?
It's really hard. I mean, as I mentioned, you can bring a lawsuit to have the board removed or to have board members removed. But I'm not going to lie, it's a long, lengthy, and expensive process. I remember when our building did it, it came around and collected money from all the apartment people, like volunteered. But it was it took a long time. Now, we needed to do it because literally the person was embezzling from the building and who is the head of the board. Election results, you should take a look at your bylaws and see how the elections are supposed to be run. I know that when we had them in person in our building, like the attorneys used to run it and they used to ask for 3 or 4 neutral people to sit in the room and watch them. Now they're moving a little bit to electronic, so I think that's going to make things a little more difficult. And, if the management company is really not doing what they're supposed to be doing, I mean, you should definitely, let the board know, let them know, make a complaint to the Better Business Bureau. You have the right to do all the things that you would do with any type of business.
Right. These are tough ones. So we've also heard these over the years. So there are original sponsors for condos, and some of them never sell units for years and years and years. So they end up with like controlling interests on the board. So here the specific example is the condo sponsor owns 58% of the shares in the building. So has 2 seats on the 5-member board and is the managing agent who doesn't implement the board resolutions. Is this legal?
So usually they'll be in the formation of the co-op or whatnot. They do talk about sponsorship, and most of the time it's limited to how many sponsor-owned apartments. 58 is a very large number. But we need to look at the specific bylaws to see if, like, are they required to have 2 on the board, or, or is that just the way that it's been going? And I know sometimes it's look, being on the board it's not an easy job for somebody who's doing it properly. So, I always say people will run for the board, but I know how much work it is, and everybody's working and has, other responsibilities. But, sometimes the best way to know what's going on is to actually be sitting in that room.
Got it. So I saw that the occupancy agreement doesn't allow the building to sub-meter our electricity, but they're doing it anyway. Is there something I can do about that?
So I missed, where does it say that they can't do it?
It says the occupancy agreement doesn't allow, or maybe just simply doesn't address the sub-metering of electricity. I know sub-metering is a newer concept, so that may have never been addressed in any kind of agreement.
Yeah, it has not come across I haven't seen it yet. But I would imagine that, when the agreement doesn't mention it, it's vague. I would wait to see. I mean, you can try to get it into the bylaws. I didn't mention in the presentation, just because there's bylaws now doesn't mean that they can't be changed or things added or taken away. Usually you need a quorum for major things, which is like 2/3 or something of that nature. But you should look at your bylaws and see, like, is there a way you can call a special meeting? Is there a way that you, even though you're not on the board, can, petition for something or whatnot to find out? But you certainly have the right to know what they're charging you for and why they're charging it.
I was on a different discussion the other day where I was advised, actually, Con Ed charges a lower rate for a sort of when it's building utility, so that if you can sub-meter and it just becomes part of your rent maintenance bill, it actually stays at a lower rate than if you have your own separate accounts. So I'm not quite sure if sub-metering is always is bad versus good. So you might want to be asking those questions also. It's from the perspective of how do you maximize lower utility costs, which is always a separate challenge for all of us right now. Okay, I'm going to jump because there's so little time and so many questions. Okay, repairs and damages. I was unable to stay in my apartment for a month because my co-op did not follow house rules of 1 week prior notice when using toxic chemicals in the building and exposed me to toxic chemicals during roof work. I was sick for 30 days because of the exposure and treated with prescription drugs. Who can I turn to for advice or representation to get reimbursed for that month's maintenance and medical expenses?
So there's 2 ways to look at it. The first, who did the work, right? So if there were actual employees of the building that did the work, then you can sue your building. Like, you can sue your co-op corporation. If it was a private company that they hired, then you should go to that person, or honestly, on your behalf, your board should be doing it for you. But if ABC Extermination came in and they're the ones who improperly use the chemicals, they are responsible for that.
Okay, so the follow-up question, I think, from the same person was, personal injury lawyers are not interested because I was only sick for 30 days. So suing the building, at least to try to get maintenance reimbursement, is one thing, but you might have a bigger problem if you're trying to sue a private company on a, personal injury sickness situation.
Yeah, it's could very well be an uphill battle, but you can only sue for what your damages are. But if you were really sick,
Yeah,
then it is hard because a lot of personal injury attorneys don't want anything that's not going to have a big payout.
yeah.
But you might be able to find like a consumer attorney, that if we're talking, if it's a matter of paying for some medications and maybe some other things, then you might be able to find a consumer, or you can go to small claims court and fill out the paper for $25. And a lot of times people sometimes will settle, just give you something to make you go away. But if you have major health concerns because of this, make sure you document it with doctors and hospitalizations and things like that, because that unfortunately can become very expensive very quickly.
So this one is more of a blending of a serious damage issue combined with bad behavior, it seems, by the board. So my apartment has serious rain mold damage due to the board not taking care of the building. This has been a 24-year issue. If I sue my board, they will charge me their legal fees, which is allowed in the proprietary lease. How can I get the board to make the needed repairs and to end the problem? I can't sue the board because of the financial burden I will accrue. Can I sue the individual board member who seems to be preventing the repairs on my apartment?
So for the individual board member, I mean, you would need to have to prove that he was doing something. If there's one board member who's the problem, then the rest of the board is supposed to come to help you, right? That's what you would imagine, right?
Right.
If you do have a better relationship with someone else on the board, I would say talk to them. Mold is a major problem, and it is a huge issue. We had someone come to us recently who actually called the city agencies and had them come in and do the mold tests and whatnot. And yes, her board was not happy with her, to be quite honest with you. But sometimes having someone breathe down your neck, and even though it may end up costing the board or costing the building some money, people can die from mold. So it's really something. It is a health hazard. So I know that there's the issue with the legal fees. If you're worried that the board will put the legal fees onto the building. But there are just, if it is that bad, sometimes it's just something you have to do.
So my upstairs neighbor had a leak which affected my apartment. This happens all the time. Who is responsible for making the repairs? My neighbor or the co-op? Or am I responsible in some way for this?
This feels like a yearly event in my building.
Yeah.
For me. We've had so many leaks. And there's always a fight. Whose pipe is it? Was it, a major pipe that is the building's, or was it the pipe under my sink? Now, if I am not supposed to have a washing machine and I have a washing machine and it overflows into my neighbor's apartment, then I am responsible. And that is something that, my insurance, I should be able to put through my insurance. I came back from vacation one year and every floor in my apartment was destroyed because the people upstairs got a washing machine. But it was their responsibility. The building wouldn't come in and take it. But if the facade of your building is in such bad shape that the rain is coming in and destroying your everything, then that's on the building.
I need a new gas stove. I guess this could be any appliance. The co-op board is demanding I get specific licenses. I think that probably means I hire licensed plumber or electrician, but they're also requiring me to hire a specific plumber. I understand, Liz, understands the obligation to have licensed plumbers and electricians and to have them have insurance coverage. I get that all the time in my own building. but can they make me hire a specific person they want me to hire?
If it is in the bylaws or house rules, if it has been passed. One thing I will tell people, be careful, is don't just have the building say, don't worry, we're going to send up one of our porters and he'll put in your stove. For your protection, you want a licensed plumber or electrician or whatnot.
Right, exactly. Okay, so same theory, the building had a gas leak and during the renovation and correction, they broke my stove and it's not workable. Who's responsible for replacing the stove?
If it's the employees of the building who broke your stove, the building is responsible. If it was a private company, the private company would be responsible. But what a lot of times a good building should do is they should take care of you and then they should go after the company. But it would be basically whoever's agent broke the actual stove.
Got it. Okay. All right, we're gonna go a little into, oh, we have so little time. Finances and taxes. I'm a shareholder who owes back maintenance. What are any resources available to me? I know you referenced that in your presentation a little bit.
Yes, there is a one-shot deal that you're eligible for, and there may be there's new programs come up all the time. So you definitely should reach out and talk to somebody.
Got it. And I know we talked about this a little bit right before we came online about putting my co-op in a trust.
Yes, a lot of co-op boards don't allow it. But if it's allowed under your bylaws, then when you do a trust for all the rest of your property, you can include the co-op.
All right. Does the Enhanced Star program for seniors apply to co-ops? And how do you apply?
Yes, the co-ops get the same tax breaks as condos and houses as far as, veterans and senior. You'll only apply once, so you don't have to keep applying every year. Normally the building puts in applications for people, but you should definitely check and make sure that when your maintenance reflects the decreased amount. And if you want a condo, then you should put in your application, provide the finances. I think you have to make less than $59,000. So there are some income limitations, but just because you're a co-op, it doesn't mean that you lose the ability to do that.
We've just put in chat sort of the websites that you actually explain the numbers and details for the SHIA program, the STAR program, tax abatement programs, foreclosure prevention program. So when you get this in a day or two, there'll be all kinds of resources there for you. You have a really noisy neighbor. Is there anything you can make your co-op board do to make them be quiet?
I mean, you should definitely put in, complaints. I mean, as I mentioned before, because you own the co-op doesn't mean that you have the right 100% to live there. So if you have somebody who's a real nuisance, they can be evicted under the proprietary lease, just the way they would under a rental lease. Now, again, it also depends, are they a noisy neighbor because they're having wild parties every Saturday, or is it that they have, 3 children? And, a lot of co-ops say you have to have rugs for that reason and things of that nature. So, you should definitely, hopefully there's somebody in your building that you trust, whether it's a board member or the super or someone, to try to figure it out. And, if it gets bad, you can always call the police, just the way you would in any other building. If I've had people say, I think they're running drugs out of the building. I said, well, then you need to call the police just the way you would, if it was your neighbor, somewhere else.
So what happens if the the hallways in my building are freezing? And that's actually causing my apartment to be cold. Does the building have an obligation to keep the hallways at a certain temperature?
They have to keep everything to the temperature that is by law. So whatever the law, if the law says that, I know, for example, one of the things that I hate about living in my co-op is they shut off the air conditioning on one day of the year and they turn on the heat because just in case it's cold, because it's illegal to not give people heat or to not, is the hallway going to be a little colder than, probably you want your apartment to be? Yes, but you shouldn't need to put a coat on to go into your hallway. And
Got it.
you can report them just the way you would report a regular landlord.
Right, right. If you believe that you have actually been hit with a maintenance increase, which is retaliation for something, how do you get that taken off of your monthly statement?
I mean, that's also hard, right? Because the person that you think is retaliating against you is probably the person who's going to be hearing the complaint. There are mediation centers and that people can go to that for free, and you could maybe try to get someone else on the board to sit down and talk to you. You certainly have the right to know why, and is it only you that are they giving you $100 a month and everybody else $10 a month? Like, they can't do that. You would need to check how your bylaws and whatnot and figure out how these things are supposed to be figured out. And try to get that person off the board. I mean, try to get someone you like on the board, someone you think is going to be fair on the board.
Got it. Okay. Sorry. Oh, our sponsor controlled board just voted in a mother-daughter team. So that's even increased their percentage of control of the board. Are there any rules against that? Sort of.
I haven't really seen those kinds of rules in many, house rules or bylaws. I mean, I know they voted them in, but the other people in the building, they must have some people there too. I mean, I know I sound like a broken record, and part of me really wishes that I could give you like a straightforward answer, but these are tricky situations. We've had to cancel I don't know how many elections in my building because we can't get people to come out and vote for which directors they want. It's really important that you do your best to try to get some people on the board that you think are going to do the best for the building, because that's what they're supposed to do, right? They are there to make sure the building is in the best way possible, so that you have a peaceful existence. You don't have to worry about stress when you go home. You don't have to worry about waking up in the middle of the night and seeing your ceiling, caving in. But it's really hard because a lot of the decisions that people make on the board, they're not illegal necessarily, or it could just be bad decision making, or in a lot of cases people on the board are people who have regular jobs and are busy and don't put the time and effort into it.
So a number of various questions that are all sort of similar theme. If I live in a co-op, can I form a tenant association? People seem to believe that renters have better rights and protections than shareholders, which is, I don't think, legally true. So
No, you can always do a tenants association.
Okay, good.
The voices of many sometimes works better than, this way they can't say, well, it's just Rosemary who's a pain in the neck if, there's 20 people with the same issue.
We went over before what buildings should be providing to you as a shareholder. Are you entitled to the amount of maintenance every other unit is paying, so you can see whether you seem to be getting too high a maintenance in comparison to others?
Usually the paperwork for the co-op will say that the maintenance is X amount of dollars per share you hold.
Right.
So someone who has a 2-bedroom apartment probably has more shares than someone with a 1-bedroom apartment, so their maintenance and their assessments and everything are going to be higher. Usually in most of the agreements, it's that ratio.
What if I'm having problems with the staff in the building? Am I allowed to get information about them somehow from the board or management company? I mean, they're unionized, so am I supposed to complain to their union, or am I supposed to be able to get responses from, I guess, the management agency?
Yeah, the management agency is the one that usually hires the employees and, is supposed to do whatever the proper background checks are and things like that. Now, if it's a rude doorman, that's very different than if, you think you have someone who's, breaking into apartments, right? I mean, depending on, the level, but it is the management agent. And if you don't have a managing agent, the board's job to, to deal with their employees. But if you're being harassed or anything like that, then, just because they're an employee of the co-op doesn't mean you have all the rights, to whether it's an order of protection or, anything like that. You still, you still have all those rights. You don't, you have the right to quiet enjoyment in your home is the term that the law uses.
I guess last question, because we've run out of time. I live in a no dog apartment building, but everybody seems to be getting permission because everybody's dogs are suddenly emotional support dogs. So I know there's some city law around that, but if everybody is suddenly calling their dogs emotional support dogs, hence a no dog building is actually filled with loud barking dogs, what can I do?
So it is hard because once they become an emotion support or a service animal, it's hard to tell people. I know that people go on Amazon and buy something that says, working dog, and puts it on, because I see dogs all over the place that, and I don't think that Chihuahua is, it's a seeing eye dog. So, but you can certainly complain to the board. If there's enough people who want dogs, they could change the bylaws and make it now a dog building. I don't, unless you specifically have something, I know you called it a no dog building. I haven't really seen in my like something that specifically says like we will never have dogs.
Yeah.
But it could be an issue, and I get it. I love dogs, but they can be very yappy sometimes when you're trying to, get stuff done at home.
Exactly. We got through almost all the questions that came in, and I want to thank you profusely for your presentation and your openness to always working with my constituents in our office. Again, everyone, you'll get all this material sent to you in the next few days. I want to thank you again, Rosemary. I want to remind everybody that my virtual older adult resource fair begins this week. Our first session is tomorrow, Friday, December 6th, and we'll be focusing on making connections while aging solo. The next session is December 12th, and we'll focus on arts and culture. And our final virtual senior resource fair session is December 13th, and we'll offer legal resources, which I think will include some other representatives from NYLAG. A link to the RSVP for the older adult resource fair, all 3 parts, is in the chat right now. So sign up if you haven't already. And again, thank you all for joining us today. Thank you, Rosemary, for the terrific work you're doing on all of our behalfs every day. And I'll see everyone soon. Bye.
My pleasure.